Good afternoon, everyone, and good morning to those on the West Coast. Presenting today on trademarks, and myself, I'm based out of the New Jersey office. I will talk primarily about the background, the overview of trademarks, the historical development, and things like that. Okay, so starting off, what is a trademark? It's a form of intellectual property. The different types of intellectual property, there's patents and copyrights and trademarks. The difference is that a trademark protects the brand names and logos that are used in goods and services. It's a commercial interest that's protected here. The main purpose of trademark is to identify that the goods and services come from a particular source. The idea is that the purchasing public wants to know where the goods and services come from. And so the trademark protection serves this particular interest. Also important to know that a trademark isn't limited to just words and designs. Pretty much anything can be a trademark as long as it serves the purpose of identifying the source of the goods or services, and it distinguishes these goods and services from that of others. So, for example, we look at a common example. If you look at the shoes, the two brands Nike and Adidas, when you see the Nike swoosh logo on a shoe, you immediately know that it is a Nike shoe, and you know the source. And when you see the Adidas logo, you see the three stripes for Adidas shoes, you know that it is an Adidas brand. And that's exactly what that's the function that a trademark protection serves. It informs the public of the source of these goods. Anybody want to take a guess on what the most valuable trademark in the world is?
Coca-Cola?
Coca-Cola, yes. Mm-hmm. Yeah.
Google?
Google, yeah, that's a good guess. So I actually thought it was McDonald's. Apparently, Amazon is the most valuable trademark right now, followed by Google, Apple, and Microsoft. What all can you trademark exactly? So, normally we tend to think of words and, logos and designs as the trademarkable property. But you can have phrases, for example, the Nike "Just Do It" line. You can trademark a color if it's a distinctive color. So, an example for a distinctive color. Anybody have a guess? Anybody can give an example for a distinctive color that is a trademark?
Crimson?
How about
Google, I will.
I
Google
think
colors.
Tiffany.
Tiffany's, yeah. In fact, that was my first thought as well. The Tiffany's blue box, right? The minute you see the blue box,
Yeah.
It's Tiffany's. Then you have the T-Mobile magenta color, right? That's also pretty distinctive. So those are examples of color. So the key thing is it has to be distinctive enough, and it has to distinguish your product or your service from those of your competition. Apparently, sounds can also be trademarked. I haven't really looked into an example of this, but I guess if you have a sound or even a smell that's distinctive enough, you could trademark those as well. Yeah, so a few technical things to keep in mind. Technically, the term is trademark when you're talking about goods, and when you're talking about services, the correct word is service mark. But we just usually say trademark in general parlance. Also, the signs, you can use that the TM sign next to a word if you just want to indicate that you are asserting your trademark right over it. You don't necessarily have to have registered the trademark in order to use the TM symbol. But when it comes to the R within the circle, that is a symbol that you can use only when your trademark is registered, with the USPT or whichever is the appropriate authority in the country. In that case, we'll move on to trademark registration. Now, is registration of a trademark really necessary? No, it's not, but it affords better protection. In most common law countries, US, India, these are all examples of common law countries. In these countries, you can acquire or develop trademark rights just by using your mark in commerce. And so these use-based rights are known as common law rights, and these exist irrespective of whether the trademark has actually been registered. But the limitation with this is that with the common law rights of trademark is that you are restricted to that particular geographic area in which you operate, right? So if you have a competitor in a different geographic area within the same country, your common law rights in trademark will not extend to you being able to, will not let you prevent those people from operating in a different geographic area. So that's, one of the main reasons to think about registering your trademark. And we have a slide on the advantages of registration. So there's a whole bunch of them. The main, the advantages of registration, one is that it puts the world on notice of your ownership of the trademark. It creates a presumption of your trademark rights throughout the entire geographic area of the country. So, for example, in the United States, if you register the trademark with a federal agency, the United States Patent and Trademark Organization, it automatically gives you trademark protection throughout the United States, with some limited exceptions, and we'll talk about that later. In addition, the USPTO itself relies on the database as a record of all the registered trademarks. So if you have somebody who's trying to register a trademark, which is a mark which is similar to yours, the USPTO itself will not authorize the registration of the mark if they find it to be confusingly similar to your mark. Registration also gives you the right to bring legal action in federal court. Otherwise, if the mark is not registered, you would have to go to state court. You also have the, once the mark is registered, you also have the ability to use the US trademark registration date as a basis for applying for the trademark registration in other countries. And that has to do with the priority date, because the date that you apply for your trademark, that gives you the priority date. And that controls for subsequent registrations. If you can show that you were the first to file, that gives you a lot of advantages with subsequent registrations. And last, of course, once you register, you can use the R symbol to show that it is a registered trademark. Any questions or comments?
Hi, Dia. This is Neha. I have one question. So you just mentioned that trademark has registration has this geographical boundaries. So, for instance, US. You can be registered for in US for a US related trademark, but for with e-commerce being so prevalent, like Amazon and all, do they really need to register worldwide everywhere, or is there another option available?
Yeah, that's a good question. So we'll talk about it a little later in the presentation when we talk about international registration.
Okay.
Yeah, but as I said, so the key thing is once you register with the USPTO, your protection extends throughout the US territory. Okay. Now we'll talk a little bit about what can actually be trademarked. But so weak and strong words. The main, the eligibility criteria for registering a trademark is that the mark that you're trying to register has to be unique, and it has to have some distinctive quality, right? So, if it's very generic and, it's something that is not really distinguishable in any way from others, they will not let you register. So, for example, I can't go and, register something like world's best immigration attorney, right? It has to be, or even something like effective immigration attorney, because they will say that it is generic and it's just descriptive. So we'll talk a little bit about the common grounds for refusal of a trademark application. There's a whole lot of examples under this, subsections under this. We'll just talk about the most common ones. One is if it sounds like another mark. So you have, you might have a mark which is written in a certain way. It's different from an already registered mark, but if they end up sounding the same, as you can see in this example here, then it's a high, there's a high likelihood of confusion, and the USPTO will not let you register it. Second reason could be if they have similar commercial impression. Next slide, Bilava. So in this example, the second mark, as you see, is it's a little different because you have that text in there, but because you're using the same logo, it creates a similar commercial impression on the public, and this will also be deemed to be confusingly similar, as I say. The third reason is if it's related goods or services. So you have a mark that you want to register for a certain category, but if you're trying to register your mark for a category which is related to that the category chosen for a pre-existing mark. So in this example, it's hats, which could be considered to be pretty similar to t-shirts and pants. Your mark will be disqualified and you will not be allowed to register. The next example is if it's merely descriptive. As with everything else in life, there are exceptions to all these rules. So even if a word is descriptive, if it's merely descriptive, as we say, it could acquire over a period of time. It could acquire a secondary meaning just by usage and becoming popular. So an example would be Kentucky Fried Chicken, right? If you think about it, it's descriptive. It refers to the geographic location, Kentucky, and fried chicken, which is not distinctive. But because it had become so popular, and the general public knows that this is a particular brand, they were able to trademark it after a period of time. Anybody have an example of a word of a trademark that you think is descriptive, but at the same time is distinguishable enough?
Dunkin' Donut?
Dunkin', yeah, that's also the word Dunkin'. Yeah, Dunkin' is a descriptive word, but it has a secondary meaning. So some brands become so powerful that they have a secondary meaning, but you have to wait. Obviously, you have to wait for it to acquire that meaning before you can register it. There's an interesting case from the 80s. So the McDonald's brand, it's so popular and so powerful. So in the 80s, there was this hotel chain which started advertising its rooms as low cost and clean and quality for a lower price. I think they were marketing the rooms at $30, $29 a night or something. And this line of hotel chains was called McSleep, right? So McDonald's started asserting its trademark rights over them, and they told them that they couldn't use it because they said the word Mac from McDonald's had acquired a secondary meaning, and they couldn't, they were trying to stop the hotel chain from operating under this name. So McSleep went to court, and they said that, first of all, we're in a different category. We operate hotels, we don't operate foods, and we don't sell burgers. But the court actually ruled with McDonald's, and they said that the word Mac had become, almost synonymous with this whole concept of affordable for a quality price, and so they had to stop using that name. So I also want to talk a little bit about, the first to file and priority rights. So when it comes to trademarks, there's two types of regimes in the world. Most of the common law countries, including United States and Canada, they follow the first to use. They fall under the first to use regime, which means that you acquire or you develop trademark rights just by using the mark, even if it's not registered, right? Whereas the other countries, the European countries, the civil law countries, and China, etc., they follow the first to file, which means that if you are the first to file for the trademark with the registry, you can stop even people who've been using the mark before you filed. Those are the two main systems in the world when it comes to trademark filings. Let's talk a little bit about international registration, as somebody had asked before. For a long time, there was no unified system of registering on an international basis. And then they came out with the Paris Treaty, the Paris Convention, which tried to, kind of unify the whole system so that you wouldn't have to go and file trademarks individually in each country. Even the Paris Convention was not really, it didn't really have, it didn't get a lot of people to sign up in the beginning. But then they added the Madrid protocol to it, which I think was sometime in the 70s, if I'm not mistaken. And with the Madrid protocol, what you have now is a unified system for international registration. And but it's only applicable for the countries that have signed up to this. I forget how many countries you have right now, maybe about 200 or so. So if you file under the Madrid protocol, and there is actually a link on the USPTO website itself for it, it gives you registration, which applies to all these countries, which are signatories to the Madrid protocol. So that's how it works with international registration. Okay, so I think that's it for a general introduction.